All right, Mr. Levine, I'm ready.
Thank you, Your Honor.
Mr. Cole, please start your video. Mr. Cole? All right, thank
Yes, ma'am.
you. This is case number 234535601.
You said the case number?
Okay, Mr. Cole, okay, do you have a good signal? Can you hear us?
It's 3603.
No, sir, I'm not asking. No,
390000.
Mr. Cole.
Yeah.
Can you hear me clearly?
Yes.
Okay, I'm not asking you for the case number, sir. I'm not asking you for the case number. I just need you to listen at this moment, okay?
Okay.
Okay. This is case number 234535601. The people of the state of Michigan versus George Cole. The defendant is charged with 1 count of operating while intoxicated. And today is the date set for a pretrial conference. Appearances, please.
Good morning, Your Honor. Christina Ritter on behalf of the people, P number 83505.
Good morning once again, Your Honor. For the record, Joseph Levine on behalf of Mr. Cole, P50966.
And Mr. Cole, state your name, your full name for the record.
George Cole.
Thank you, sir. Today is the day set for a pretrial conference. Mr. Levine, how are we proceeding?
Your Honor, Ms. Prey from my office has had an opportunity to speak with Ms. Ritter. My understanding is there's going to be an offer to add a 2nd count of operating while physically impaired. Mr. Cole understands he has a right to trial on either the original or the amended charges. He is going to plead guilty to the added count 2, upon the court's acceptance of which the people are moving to dismiss count 1. We're respectfully asking for an evaluation pursuant to People versus Cobbs for no upfront jail. I can allocute on that if you wish.
First, I'm gonna correct the offer, and there's no adding count 2. We're just gonna amend count 1, correct?
Correct.
Okay, and then you're asking me for a Cobb's evaluation. I never give people upfront jail time.
Fair enough, Your Honor.
I take it back. It's a rare occasion that I give people upfront jail time, unless there's an agreement with the prosecutor. So, yeah, that's your Cobb's.
Okay, thank you very much, Your Honor.
All right, and so Ms. Ritter, is that the people's offer?
That is correct, Judge. That is the people's offer.
Mr. Mr. Cole, you want to accept the people's offer?
Yes.
All right, Mr. Cole, I'm going to share my screen in a minute. And on my screen, oops, you're going to see an advice of rights form. My question to you is, have you had an opportunity to review for yourself or to go over with your lawyer your constitutional rights? Mr. Cole, have you had an opportunity to review for yourself or to go over with your lawyer your constitutional rights?
Yes.
And when you did that, Did you understand your constitutional rights?
Yes.
Do you understand that this is a misdemeanor? And therefore, as stated in number 5, you have a right to a trial. However, if I accept this plea from you today, you will be giving up your right to a trial as stated in number 6. Do you understand?
Yes.
Has anyone threatened you in any way or promised you anything that was not placed on the record today to get you to enter into this voluntary plea?
No, ma'am.
I apologize, I didn't hear your answer.
I said no, ma'am.
Okay, are you currently on probation or parole?
No.
Finally, drawing your attention to number 11 on the advice of rights form, do you understand that by entering into this voluntary plea, you may be giving up your right to an automatic appeal, and if were to change your mind about the plea, you would either have to request permission of this court to set aside your guilty plea or request permission of the circuit court to appeal the conviction. Do you understand?
Yes.
With that understanding, do you still want to give up your right to a trial and enter into this voluntary plea?
Yes.
Raise your right hand for me, please. Can you raise your right hand for me and let me see it in the camera? Thank you. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
All right, who's going to voir dire Mr. Cole? You can put your hand down. Who's going to voir dire Mr. Cole with respect to the factual basis?
I'm happy to do it if you like, Your Honor.
You may.
Thank you. Mr. Cole, is it true that on or about December 26th, 2020, you were operating a vehicle on M39 Southfield Highway in the city of Detroit?
Yeah. Yeah.
And prior to doing so, had you consumed marijuana?
Yes.
You were stopped by members of the Michigan State Police Department,
Yes.
and they had you perform a series of field sobriety evaluations.
Yes.
And based on that, they arrested you and drew your blood.
Yes.
And you have seen the toxicology report indicating that that was sent to the Michigan State Police Crime Laboratory and tested positive for the presence of THC. Correct?
Yes.
And at the time of this offense, you did not have a medical marijuana card issued by the state of Michigan. Is that true?
Yes.
Is the court satisfied with the factual basis for the underlying offense?
I don't know, actually. I don't think I'm satisfied. So.
Okay.
But hold on, counsel. So apparently this is not based on alcohol, but based on marijuana. Okay, and whether or not a medical marijuana card is irrelevant to the operation of the motor vehicle because the law allows for people to smoke weed, to my chagrin. So maybe I need a more of a factual basis with respect to the I guess I wanna call it field sobriety. Miss
I can do that.
Ritter. So, yeah, so I'm not satisfied yet because he could smoke weed, marijuana, whatever. He can smoke marijuana and operate a motor vehicle. There's nothing that prohibits it, which they didn't think it all the way through. And then at some point, he must have did something that drew the officer's attention, and then notwithstanding him not having a medical marijuana card. So can I get a little bit more factual basis?
Yes, I'll be happy to. And I'll just note for the record, Your Honor, the reason I didn't ask for more was this offense happened 4 days before the recreational marijuana permission statute took effect on January 1st of 2021. So as of the date in question, it was still unlawful to operate with any presence. But I'll be happy to continue the board here.
No, so, thank you. That was very relevant information for the court. What's the date of the offense again?
The original underlying offense was operating under the influence of a controlled substance, but the statute also allowed the punishment of presence of a controlled substance unless you had a medical marijuana card. He's pleading to operating while impaired due to the use of a controlled substance.
But I said, what's the date? I'm sorry.
Oh, I'm
What was the
sorry.
date?
I'm sorry, Your Honor. December 26th, 2020.
Okay, yeah, thank you. Yeah. So now, actually, the court is satisfied. Ms. Ritter, is people satisfied?
No.
Okay, what else? You may.
Mr. Cole, did the consumption of that marijuana impair your ability to drive or operate a motor vehicle on the day in question?
Yes.
All right, the court is satisfied. I will accept the guilty plea to one count of operating while visibly impaired. Having accepted the guilty plea, the court is going to set the matter for sentencing. And I'm gonna set sentence for how many do I have on March the 19th? Counsel, is March 19th a good day for you?
That'd be in the morning, Your Honor?
Yes.
Yes, that works. Thank you.
All right, Mr. Cole. Mr. Cole's signal is a little shaky this morning. So I don't want to have any issues on the day of sentencing. If he wants to do his sentencing via Zoom, that's okay, but he might have to come to your office or just make sure your signal is better. So Mr. Cole, you have the right to be sentenced in person, but you may consent to being sentenced on Zoom. So I am giving you the option, but your signal is a little shaky.
Okay.
Which do you prefer?
Zoom.
All right, the court is gonna set sentencing March 19th on Zoom at 9 o'clock. Prior to the sentencing, you're going to submit to a pre-sentencing investigation and substance abuse evaluation through the probation department. They are going to contact you by telephone. If they cannot reach you, they will leave you a message and mail you a letter directing you to contact them. Please make sure that you respond to the phone call or the letter so that I can have a proper pre-sentence investigation on the date of your sentencing. Mr. Levine, if you could please call my courtroom to make sure that we have the current address and phone number for Mr. Cole. The court's phone number is 313-965-2295. Anything further for the record?
No, thank you.
No, thank you very much, Your Honor. I'll call your staff in a minute.
All right, then we're all set. Have a great day. Stay safe.
You too, Your Honor. Thank you. Thank you, Ms. Ritter.
All right, Mr. Cole, you're all set.
Thank you.
You're welcome. Okay, let's see. I'm ready on, oh, I didn't bring the sheet down. Yeah. some of these devices identified, and then I'll be ready. I think on Brooks, we can hear me.
Your Honor, I'm sorry. Ms. Brooks has asked for breakout with me after all.
Ms. Brooks, please accept to join the breakout room. And the lawyers will be in the speak. Go ahead, Ms. Beats. All right, when prompted to do so, please unmute your device and state your name when prompted to do so. Can the individual on the iPhone that I'm sending a prompt to, please unmute and state your name?
Clay Lamar Mayberry Jr.
All right, I didn't hear you. Say that again, please.
Clay Lamar Mayberry Jr.
Thank you. Thank you, Mr. Moran. It's retained, though. I'm gonna go ahead, I'm gonna. All right, the person identified with the last name Moss, please unmute and state your name.
Lindsay Moss.
Thank you. Person on the Motorola, please unmute and state your name. The person on the Motorola, please unmute and state your name.
Clyde Lauren.
Say that again. Say that again, please.
Clyde Lawrence.
Thank you. And finally, Ken Richards Galaxy, who keeps unmuting without being prompted to do so, please state your name. Mr. Mariah, you could change the Motorola to Clyde Lawrence. Can Richards Galaxy please, well, what happened to Clyde Lawrence? Okay. I don't know what happened to Clyde Lawrence. All right. Can the person?
Clyde Lawrence is here, please.
Okay. Were you on two devices, Mr. Lawrence?
No, I'm just on one phone, please, ma'am.
Also, that was Richards Galaxy unmuting without being prompted to do so, and that's who Clyde Lawrence is. All right. Can the person on the non-video telephone please press *6 to unmute and state your name? And state your name. Say that again, please.
Yes. Tina, first name, last name is Cunningham.
Ms. Cunningham, how did you get on the telephone? You came earlier?
Yes, and I couldn't hear, she couldn't hear me, and then, I don't know, I got back on there and nobody came back on, so I just called in.
Okay, well, you have to hang up and dial and come back on video.
Okay,
Thank you.
thank you.
All right, everyone can start your video. Mr. Mayberry, I'm gonna send you back to the waiting room. Your lawyer is not here yet. But they should be here shortly. And then Mr. Lawrence and Ms. Moss, please accept to join the breakout room and wait for a lawyer to come in to speak with you. Do not leave the breakout room until you have spoken with a lawyer. Ms. Payne, FYI, your client still isn't here.
Your Honor, I have sent her an email and I've also tried to call her. There is a co-defendant, and the last time we were here, they were using his phone.
Okay, well, I don't know, but your client isn't here.
Okay.
So we trying, but your client isn't here.
Okay. I will continue to try to reach her, Your Honor.
Okay.
Thank you.
I'm sorry, it's the Brian Hill standing there. Mr. Miller.
What's Mr. Miller's first name? Is that the same Mr. Miller? I'm going to show cause here.
Clayton Patrick.
I don't know. Can you look and see Mr. Lannis
Oh, okay.
case, who Mr. Miller was? Are we ready on Brooks?
Ready on Brooks, Your Honor.
Good morning, Ms. Duplessis.
Good morning, Your Honor. How are you?
Wonderful, thank you. Ms. Stevenson, did you speak with Ms. Cunningham?
I did not, Your Honor. She had some problems with her audio in the breakout room.
Ms. Cunningham, please rejoin the breakout room. Ms. Brooks, please stay muted. Ms. Duplessis, your client isn't here.
I have had no contact with her, so I do not have an explanation for her absence. This is our capious day, of course.
Right, okay, well, Mr. Flanagan will call you, if she comes before the end of the docket, otherwise, Katie is her.
That would be great. Thank you so much.
All right, you're welcome.
Have a good day.
You too. Okay, well, I need a show cause file. So let's get that. All right, I'm gonna just see who this Motorola is, and then I'm ready on Brooks. Ms. Stevenson, who talked to Dom Singh?
Mr. Murad?
Can you find out from him if the co-defendant was with them at the time? Because she's saying they were using the same device.
Yes, Your Honor.
Can the person on the Motorola please unmute and state your name? If you
That's
said
Ms.
something, We can't hear you. Who is this?
She's saying Miss Pratt, TLC Pratt.
Oh, that's the co-defendant. Ms. Pratt, what's the device and why are you breathing hard in the phone? Are you okay? Hello?
Oh, man. Hear me now?
I can hear you now. Just can't try to remember that you're on court, okay?
Okay.
State your name again.
Tielza Pratt.
Okay, Ms. Pratt, I'm gonna allow you to start your camera, but you may need to come to court because it sounds like you're having difficulty. Try to start your camera.
Okay.
Okay, now I can see that it looks like you're at work, but if you can't, you're gonna have to leave work and come to court. If you can't get a good signal, your choice to go to work today was your choice. But I can't hear you, you're freezing up, you need to come to court. Ms. Payne?
Yes, Your Honor.
Okay, this is your client, but she might need to come to court. She clearly is at work. She doesn't have a signal. She's freezing up and she's gonna have to come probably in the court.
Okay,
So I'm getting ready to do another case. I'll send you both to a breakout room, but she might need to come to court.
all right, I'll see what I can do, Your Honor.
All right. Ma'am, come in the camera and accept to join the breakout room. Ms. Brooks, start your camera. I'm ready on.
Come on, Judge.
Hold on, ma'am, hold on. I'm ready on case number 234442101, the people versus Lynise Devon Brooks. Devine is charged with 1 count of assault or assault and battery. Today is the date set for sentencing. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people, I have a complaint when I was present in the courtroom this morning. Ms. Watkins, can you say the circulator for record? Yes, my name is Gwendolyn.
Thank you.
And for the record, Your Honor, Janice Stevenson appearing on behalf of Ms. Bonita Brooks. Ms. Brooks, ma'am, please say your full name.
Bonita Devon Brooks.
Thank you. Today is the date set for sentencing. Now you may have a seat. Today is the date set for sentencing. I have had an opportunity to review the pre-sentence report. With respect to the report itself, are there any additions, deletions, or corrections on behalf of the people?
Yes, Judge, just one correction on the face page. So under plea agreement, probation said that no plea agreement was given to probation. That's because there was no plea agreement. This was actually a bench trial. And the court, yes, the court found Ms. Brooks guilty count 1. And then again, convicted by, it was not a plea. A guilty verdict at a bench trial. Oh, nothing else on behalf of the people.
Anything on behalf of Ms. Brooks?
Yes, Your Honor, Ms. Brooks and I have had the opportunity to review together the pre-sentence investigation report consistent with the people's representation. And I would offer the following correction on page 7, Your Honor. the evaluation and plan. 1, 2, 3. I guess three lines down, that in the sentence that ends the third line does say there was no plea agreement. The defendant pleaded guilty as charged, and as the people have just stated, this was a waiver trial wherein the court did find Ms. Brooks guilty of 1 count of assault and battery. Then back to the face sheet, Your Honor, this is something I say pretty consistently, I think, at sentencing, but the caption on the face sheet reads prior criminal history. And we just, want the court to take note of the fact that she's not been convicted of anything before this. So Ms. Brooks does stand ready for sentencing. Other than those corrections, we have no additions, deletions, or corrections, and she's ready for sentencing, Your Honor.
With respect to sentencing, is there anything on behalf of other people?
Yes, Your Honor. So there was a recommendation, Your Honor, from probation for 24 months of a probationary term. If the court remembers, this is a case where there are 2 next door neighbors, and it seems like there's been quite a few between the 2 for quite some time, Your Honor. As the court does remember, we did have a bench trial. And after the bench trial, the people still received information from the complainant witness, Ms. Watkins, who is present today, that Ms. Brooks is still not abiding by the court order. I believe we had an emergency bond hearing where the court did order Ms. Brooks' daughter, and I believe it was her niece, not to come to the address. According to Ms. Watkins, she has video that the daughter is still coming to the address. Ms. Brooks is still threatening her. And I believe that in this instance, Your Honor, again, these are 2 next door neighbors, and I know that the court is not here to babysit the 2 neighbors and try to find out what's going on between the 2 neighbors from this one feud. However, Your Honor, the people are asking the court to give a lengthier probationary term instead of the 12 months. I'm not saying the 24, but we are asking for more than the 12 months in this case, Your Honor. Again, there is an ongoing feud between the 2 neighbors, and it seems like it's a nonstop issue. So I believe that a lengthier term for Ms. Brooks will be appropriate, so that Ms. Brooks does take this court order serious and this court's direction to keep absolutely no contact from Ms. Watkins serious in this matter, Judge. And Ms. Watkins is here today, Your Honor. So I would ask Ms. Watkins if she would like to make a big impact statement to the court at this time, Your Honor.
Okay. Thank you. Ms. Watkins, would you like to speak to the court regarding the incident? Okay. Can you come up to the podium? Or she can stand at your table. Okay. She should come to the podium so that I can make sure Ms. Stevenson and Ms. Brooks can hear her.
Good morning, Judge Bryant.
Good morning.
I was always told that you cannot live your best life without God. And my prayer warriors lifted me up this morning. I was homeless before I bought my home in February 2017. I slept in my car to rub every penny that I had, being my husband, to buy us a home. We bought our home in May 2017. Detroit Progress tried to steal our cash for our home. We had to get help from Lakeshore Legal Aid, and they helped us retain our home. Me and Ms. Brooks was very cordial, very cordial. I was a new homeowner, and she was a homeowner as well. And she explained to me where our district manager building was, the trash pickup. My husband was even taking her daughter back to school. Her daughter started showing strange behavior, and I stopped my husband from taking her daughter back to school. I have been back and forth with the police department, and Ms. Brooks did say something right. Detroit Police Department do need to do their job. Ms. Brooks is an evil person, and it's a difference between being mental and evil. Anytime when you take your car and you struck my husband with your car, and then you send me your car repairs afterwards, I was in Ms. Judge Lynn Pierce courtroom when she granted me our first 2-year PPO. And she looked at me and my husband, and she said, I feel sorry for you both. Because she said this PPO is not going to protect you. And it hasn't. It's been 6 long years, and Ms. Brooks will not stop. And she still disregards the law. So I know at this point, she's not going to stop. I sat in front of the neighborhood police officers, and they want to tell me that Ms. Brooks has a mental problem. So I asked them a question. What are you going to tell my 8 grandkids when Ms. Brooks really do something really bad to me and my husband? It got completely silent. There was no words. There was no conversation back for me. All they could say is, well, we sorry. There's nothing that we could do for it. I've been going through this with Ms. Brooks for 6 long years. Bullies don't just come as teenagers in high school. They are also adults who think they have the right to break the spirits of others so they can feel better about their miserable lives.
Anything further?
One last thing, Your Honor, as far as the restitution, people believe that there was no restitution word in this matter, so people are okay with restitution. Unless it only happens.
On behalf of the defense.
Thank you, Your Honor. So Ms. Brooks and I, again, have had the opportunity to review the pre-sentence investigation report.
Ms. Easton, I apologize. Give me 1 second. Mr. Miller.
Good morning, Judge.
Good morning. Mr. Miller, did you receive the pre-sentence investigation for Ms. MIBryant?
Yes. Yep, I've got it. I just need to speak with my client in the breakout room briefly.
Okay, that's why I was asking. I'll bring your client in and I'll send you both to.
Thank you.
You're welcome. All right, Mr. Mayberry, I'm gonna send you to the breakout room so that you can speak with your lawyer. So please accept to join the breakout room number 15. All right, counsel. Okay, Ms. Dixon, I apologize for the interruption.
No problem, Your Honor. So, again, Ms. Brooks and I have had the opportunity to review the pre-sentence investigation report. Ms. Brooks and I have had the opportunity to have numerous conversations throughout the life of this case. I've had an opportunity to review a lot of video footage and a lot of court records, Your Honor, which were not relevant and therefore not even offered during the trial. And I do have one piece of video footage that I'd like the court, if I'm permitted, to take a look at, which I think is relevant because I think it speaks to, if the court's interested, but I think it speaks to how very sad the situation is between both parties, and the fact that these neighbors just have not been able to get along with each other. I don't know what really happened. Ms. Brooks has given me some information that, again, I just don't know that is even relevant at this point as to what happened between her and Ms. Watkins and what caused the deterioration of their relationship and what role Ms. Brooks' daughter or Ms. Watkins' husband had in that situation. I don't know that all that is really relevant here, but it is, this is a bad neighbor situation, to the point where Ms. Brooks advised me on Friday that she is very, very, very seriously considering moving away from her home, which she has owned for 20 years. It's been her behavior on the date the incident which brought us to court. She's going to speak to how irresponsible that behavior was and how inappropriate that behavior was. But it's, not an isolated situation. It's not an incident that should be considered in a vacuum. There is volatility between these parties. Police reports have been made against both parties. The police have been out there at the request of each of the parties. So it's a bad situation. Ms. Brooks called me last week and told me that her daughter, she wanted to know whether or not your court order prohibiting her daughter from coming over to the house was still in effect. I told her I had heard nothing from this court indicating that that court order had been lifted, and she did admit that her daughter went over to the house to pick up her mail. Ms. Brooks vehemently denies having had any contact with Ms. Watkins, had an opportunity to see herself on that video that the court saw and concluded behavior, whatever the reason or whatever she thinks caused it, was absolutely inappropriate and not to be repeated. She has taken this court's order seriously to the point where she's prohibited her person, they call her niece, and prohibited her own child at this court's order from coming to her home, made her own daughter move out of her house because she doesn't want to defy this court's orders. Ms. Brooks has had no prior criminal history.
I'm sorry to interrupt. Can you all remind me which case this is? Is this the case with the fence, or is this the case with the what you call it, from across the street?
It's both. So the fence was the bond violation, and the across the street is the actual incident.
Because I was having memories of both. Okay, thank you. Okay, go ahead.
So again, I want the court, if it please the court, I would like the court just to take a look at one incident that happened between these parties that was not admissible because it was not I didn't even offer it at trial because I didn't, as an officer of the court, I don't know that I found it to be relevant for my trial strategy. Thank you, Your Honor. If I can do it.
Ms. Payne, I'm gonna put you and Ms. Pratt back in the waiting room.
Okay.
And Ms. Pratt has stopped working. And I'm not gonna look up in the ceiling and all of that. I'm not. But I'll put you back in the waiting room and brief me into this case.
I can't figure out how to make my screen big enough to get the share screen. Oh, wait, let me see if I do it like this. Share screen option. Okay, so Your Honor, as the court is aware, Ms. Brooks and Ms. Watkins are directly next door neighbors. And I think I don't know if the court recalls that at the time, the video from the trial showed Ms. Watkins sitting in a kind of burgundy colored Ford F-150 type truck. And so that is just as much video footage as Ms. Brooks was able to get of.
But what did I just see? You didn't tell me anything.
Oh, I'm sorry. Okay, I'll try to do it again. That's a video of Ms. Watkins purposefully, intentionally backing over Ms. Brooks' trash can.
So my question is, whose house is the truck in front of?
I said it the wrong way. That is a video of Ms. Watkins intentionally backing over Ms. Brooks' trash can.
Right, but then whose house is the truck sitting in front of?
So when it starts, it's sitting in front of Ms. Watkins' home, I believe.
So Miss Brooks' home is the home with the car in the driveway,
Yes.
and Miss Watkins' home is the home that the burgundy truck was sitting in front of.
Yes, Your Honor. And Ms.
And the
Brooks
trash
or
can,
whomever
hold on,
puts,
I'm asking.
oh, I'm sorry.
The trash can the trash can that you're saying belongs to Miss Brooks is
Is in
on
front of
the,
Ms. Watkins' house.
okay, thank you. And then Miss Watkins backs up and pushes it over. Is that what I'm seeing?
Yes, Your Honor.
Or somebody in the burgundy truck backs up and pushes it over?
Yes, Your Honor.
Okay,
So,
thank you.
and I only just, I wanted the court just to have a just a glimpse into how um toxic the relationship between these two neighbors is. I mean, it's not okay for Ms. Brooks to put her trash can on, the other side of her own driveway. That's not okay. But, civility between neighbors, that's not the way that civil neighbors respond. You don't just back over the trash can like that. And so I understand frustration on the part of both of these individuals. But Ms. Brooks has to understand that right now she stands as the defendant before this court. And so her conduct is the conduct that's going to be monitored so very closely by this court. And she's doing what she knows to do to make sure that she doesn't, come back here as a defendant or that she doesn't suffer advanced sanctions from this court. Again, even to the point of considering as a remedy, moving out of her home where she's lived for the last 20 years. I did have an opportunity to read through the probation officer's analysis of Ms. Brooks' behavior. So I don't know that I would agree, and I don't know that there's been any psychiatric or even psychological diagnosis, Your Honor, that would support the probation department's contention that on page 7 in the third paragraph down 2 lines from the bottom, that Ms. Brooks exhibits signs of paranoia. And I don't know that I would say that, as the probation department concluded, that behavior or that conclusion is supported by the police description of the offense. There's been a lot of volatility between these neighbors. There's a lot of problems going on between these neighbors. So for Ms. Brooks, according to the police department, to be concerned that people are maybe videoing her house or filming her license plate, that stuff is going on between the two of them. There's really weird, crazy stuff happening between these two houses. Ms. Brooks has shown me photographs where she sees that cameras pointed from Ms. Watkins' house directly to Ms. Brooks' house. And I told Ms. Brooks, Ms. Watkins can put cameras anywhere on her house that she wants to. That's her house. And they can look at anything she wants them to look at. That's her house. But for Ms. Brooks's position, it's just making it difficult for her to live there. And so she's really thinking about moving. I did want to say that in the victim statement portion of the pre-sentence investigation report, that I don't know if this is what Ms. Watkins reported, but the victim's statement says that while she was sitting in her driveway, Ms. Brooks came up to her window with what she thought was a gun. And if the court recalls the trial, that is not what it all is consistent with the video evidence, that all of this behavior took place on the part of Ms. Brooks from across the street. That there's no video evidence. The video evidence did not support that recitation that she thought Ms. Brooks, she came up to her car with a gun. So this is a mess, and it's a sad mess. It's very unfortunate. But the bottom line is that Ms. Brooks is not trying to go to jail. She's not trying to engage in any course of it's just a lot of volatility between these people, that the real, honest to God, unfortunate remedy may be that Ms. Brooks has to relocate. And that's sad. But they were cordial, they were neighborly at one time. And they know what happened to destroy that cordiality. And I agree with the people that the court should not be placed in the position of babysitting anybody. But Ms. Brooks is not trying to do anything to defy any court orders. Her daughter did go to the house to pick up the mail, but Ms. Brooks denies having violated this court's no contact order.
Did she call the police when did she call the police on her daughter when her daughter came to her house to pick up the mail?
No, she did not, Your Honor.
Oh,
She did not. So I am asked the court to give Ms. Brooks an opportunity to demonstrate that she can live peaceably in this community, even if that means she has to go live someplace else. I'm asking the court to, I don't know about the anger management recommendation. Certainly, I don't think that a course of anger management would hurt anybody. I always say that.
Ms. Brooks,
but
you
I don't know
continue
if that gets to it.
yourself. You keep unmuting yourself. Every time I mute you, you unmute yourself. Can you please stay muted? For the 5th time, I'm muting you. Please stay muted until asked to unmute by the court. Ms. Stevenson, it was difficult for me to hear that last part because Ms. Brooks' device is giving me feedback and she keeps unmuting.
Okay. All right. And we're muted now. So again, looking at the fact that we don't have any prior criminal history on the part of Ms. Brooks, and looking at the fact that, she has a traffic balance with the 36th District Court, but nothing lengthy that I see with some of my clients. I do believe that she would be a good candidate for probation. I believe she would respond favorably to probation, Your Honor. And we would ask for that sentence from the court.
What are we doing on Moss?
Moss is going to have to retain. Oh, thank you, Mr. Murad, for getting ready to chime in.
That was correct. Moss is going to have to retain.
She exceeds our income guidelines, Your Honor.
All right, would Ms. Brooks like to make a statement on her own behalf?
Yeah, sure. I would like to say I never meant to intimidate anyone, and I would like for you to forgive me for my intimidation. And I would like to ask if you could, after I complete everything, expunge this off my record.
Anything further?
That's it, Your Honor.
All right, so of course, the court has had an opportunity to review the pre-sentence report. I've had an opportunity to listen to the testimony at trial. I had an opportunity to listen to some other things, at the bond violation hearing, and I'm ready to impose sentence. Well, I'm almost ready to impose sentence, but I'm gonna proceed and then we'll see how that takes me. Yeah. I'm gonna start by saying that wherever Miss Brooks lives in the world, wherever she lives in the world, wherever, hold on, let me. All right. Wherever Miss Brooks lives in the world, Miss Brooks is gonna be with her. Everywhere she goes, in the whole entire world, she's taking herself with her. No matter what her neighbors, who her neighbors are, Miss Brooks is gonna be right there with herself. I'm not a clinician, neither is probation. And that's why I'm gonna have somebody who is better equipped to talk to Ms. Brooks so I can decide if I'm gonna send her to the mental health treatment court, because that is delusional. Who cares if I see my neighbor recording my license plate? My neighbor lives right next door to me. It is delusional to fixate on my neighbor is recording my license plate. My neighbor can see my license plate. She literally is parked at the end of her driveway with her trunk to the street. Anybody who wants to can come out and take a picture of her license plate. If she didn't want somebody to see her license plate, she would hurry up and come home and back in to her driveway. Now the only way my neighbor could get my license plate is if they catch me leaving out or if they come on my property. Now they're wrong for coming on my property. Additionally, I'm not sure, I'm not sure about the video that you showed me today, but what I know is Ms. Brooks started it. Now, did the victim act according to what a rational person who's trying to avoid conflict and live in peace with everybody should do? No. If my neighbor put their garbage can on my part, would I run it over? No. But if I have a conflict with my neighbor, why would I put my trash can on in front of their house? It's not even like they live on the other side of the street. So like one morning when I woke up and I said, why is the garbage truck out here so early? Because they never come early until I didn't put my trash out there the night before. Now I hear the garbage truck. Now they're coming down my side of the street. So the only way for me to get my trash picked up that day is if I take my trash can, move it to the other side of the street. But because I'm neighborly, as people should be when they have neighbors, I would literally ask my neighbor. I would have previously asked my neighbor before this, because we're neighborly in where I live, where I've ever lived in my entire life, because I show myself neighborly. So I would already know that my neighbor thinks it's okay if I miss the trash coming my way, sure, you can pull your trash can over here. It's not hurting me. First of all, it's on a public street. Let's be clear. Let's be clear. When I put my trash can in the street, it's the public street. It belongs to the city. You have no rights to it. Not the victim, nor the defendant. It's the street. You have no right. I can park in front of your house if I want to. It's the public street. It's the public street. So everybody is behaving badly and poorly. Let's say that. If we were trying to be peacefully, and I just didn't want your trash can in front of my house, if I did push it with my truck, I was only gonna push it in front of your house. If I was trying to be petty, you see what if I was trying to be petty, I might have just pushed it right there so it was blocking your car. So that when you came out, now you gotta pull it on your side. If I was being petty, that's what petty neighbors do. That's why neighbors can't get along sometimes, because y'all being petty. Miss Brooks trying to act like, oh, I didn't mean to intimidate nobody. Yes, you did. You meant to intimidate them because you felt like they were intimidating you. Could be, or you could be the original agitator. You know, I play this game that I'm getting ready to give up, playing, and Monopoly Go, and then some of your friends destroy your board, then they show up on your revenge thing where you could get them back. And I told my one friend, I said, well, by the time we get each other back twice, we don't know who started it. We don't know who was the originator of doing it. Now every time you just keep showing up on my board. It's probably been going on so long, y'all don't know who started it. But the only person in trouble right now is Miss Brooks. And then I highlighted some things that does cause me to believe that there's some type of mental health issues going on. And if there are no mental health issues going on, Ms. Brooks might need to get locked up. That's where I'm at right there. I'm giving her the benefit of the doubt that there's some mental issues going on. Some things that maybe she needs some assistance with. Otherwise, I might adjourn the hearing and she might need to come in person and go behind that great door. Because she's being petty and not abiding by my orders. Because here's the thing about that thing. I don't know when that video was taken with that trash can being in front of that house. But if it was taken after my no contact order, she kind of violating the order. You come in on my property. I don't know how she had to come over there and put that trash can in front of their house, which was petty all the way around. They live on the same side of the street. So when the trash truck comes, they just picking up both of their trash right one after the other. It was no reason, none, zero reason for Miss Brooks to put her trash can in front of I don't want to keep calling her Victor. What's her last name again?
Miss Watkins.
Miss Watkins' house. It was no reason. When Miss Brooks' daughter came to her house, if it was my daughter, I'd have called the police on her. Police, my daughter coming over here and the judge said she can't come over here. I need y'all to hurry up and get here. She breaking in. She breaking and entering a dwelling without owner's consent. I do not consent to her coming in here getting her mail. But no, because Miss Brooks is obstinate and refractory, she said, come on over here and get your mail. The judge can't tell me what to do. Now, she gonna ask you when it's come time for sentencing, was I supposed to let my daughter come over here? She should have been asking you that before the daughter came over there to get the mail. I I promise you, if I tell my grown daughter today, don't come to my house, don't come to my house. The judge said you can't come to my house because you over there fooling with the neighbor. You messing with the neighbor. The judge said don't come over my house. I guarantee you she's not gonna come. Why? Because she's gonna be scared of me. She know I'm gonna call the police on her. Oh, you at my house, I'm calling the police. And every time I'm gonna have a police report when my daughter come to my house. So you're not gonna just throw a rock and hide your hand. You're not. You're not gonna just, oh, I can't control my kids. Well, then tell them to stop coming over your house. Look like you might need to move from your kids. But you're not gonna try to pretend like, oh, I didn't know I was intimidating somebody. Yes, you did. Oh, look what she did. It takes an interesting person. And I'm going to say again, one with some mental health challenges, to present a video where I'm in the wrong. I threw rocks on my neighbor's thing, and now I'm gonna show the judge how my neighbor is pushing these rocks on my property. You don't want to throw the rocks on their property. You're the one who put your trash can on in front of their home for no reason. None. Zero. Zilch. No reason. There was no construction that I saw in front of your home. DTE didn't have your house blocked off. And if I was going to put my trash can in front of a neighbor's house because my own home is the water and sewage is in front of my house, I can't put I'm definitely not going to put it in front of the house of the person that I'm having a conflict with. Put your phone back down. Put it back where it was. Because the last time I checked, I was literally in the middle of your sentencing. Put that phone down, ma'am. Ma'am, don't do that. You can show me your hands now. I literally just saw you get up and get the phone. I don't care if your hands are empty in this moment. You literally just got up on the camera and picked up that phone. Good morning, Mr. Page.
Good morning, Judge. How are you?
I'm wonderful, Mr. Page. How are you doing?
I'm doing okay on this Monday morning.
Don't get tired of me, Mr. Page, yet. You just start working here. Don't get
Never.
tired yet.
Never.
Mr. Page, I'm giving you a lot of work. Just know that.
It's okay. I already know, but it's all right. It's all right.
Security from me, Mr. Page. Well, Mr. Page, you've had an opportunity to hear some of my situations. So Ms. Brooks is here for sentencing today. There was a recommendation in the probation order for a mental health evaluation. And I do understand, again, the new procedure for your court, but I do want to take a break in this moment. And I just want you to speak with Ms. Brooks to I don't know, get a little bit of understanding of it, even if you think that she, might need to come at all. Like, aside from the fact, well, I guess her eligibility would hinge on whether she needs to come, that's it. But I don't think, let me.
From what I read, it looks like she never had a mental health evaluation and she denies any substance abuse or anything. So I'm not quite sure, but I can definitely talk to her and get some information. And
so maybe that's where I need to start, of getting the mental health evaluation first before I bring you all involved.
Correct.
Okay, then let's do that. Thank you for that. Because you are correct in both of those, and I was trying to see something, but they're not doing what I need them to do. Okay. And I didn't highlight it. Oh, yes, I did. So you're correct. She denies it, and she tested negative.
Yes.
Way down there on page 8 at the bottom. I'm having to talk to Mr. Farmer about that. So this is what I'll do. I'll allow you to go on about your business. And then I will order that she submit to the mental health evaluation, and then we can go from there.
And then we'll
see.
come back. Okay.
Okay, thank you so much, Mr.
Oh,
Petty.
no problem. No problem, Judge. You have a great day.
All right, you also.
Thanks. Bye-bye.
Okay, so that being the case, I am ready to impose sentence, and I'm gonna do so in the following manner. Court is gonna impose 24-month probation. That will put us with a final review date of February something, 2026. Mr. Flanagan, find that date for it. And then part of the reason that I'm extending it for so long is pending the mental health evaluation. So pending the mental health evaluation, because I don't want to do 12-month period and then have to try to deal with Judge Holmes. So the court is going to order the following conditions of probation. You shall not violate any criminal law of any governmental unit. That means no new cases. You must not leave the state of Michigan without consent from the court. You must make a truthful report to probation on a monthly basis. And you must notify probation immediately of any change of your address, phone number, or employment status. You will pay the following fines, costs, and fees. Mandatory cost of $210, $100 attorney's fee, $300 fine, 0 restitution, $840 in oversight fees. Of course, that's at a rate of $35 per month, and of course, it will be prorated if she is discharged early. $50 pre-sentence investigation fee. For a total of $1,450. Final review date will be February the 12th, 2026, if we get to that point. You shall not use or possess any illegal substance. You shall not use or possess any marijuana without a valid medical marijuana card. You shall not use or possess any opiates without a valid prescription and letter of explanation from the doctor. You shall not drive without a valid driver's license. And according to the report on page 3, at this time, your license is valid. You shall not use or possess any handguns, firearms, anything that looks like a handgun, firearm, anything that might be interpreted as a handgun, firearm. You shall not possess it. You shall submit to random urinalysis, not on a monthly basis, but whenever at the discretion of probation. You shall submit to a mental health evaluation within 90 days. You shall attend 18 weeks of anger management. You shall have absolutely no contact with the complaining witness. That means including in front of her house. Don't park in front of her house. Don't put your garbage can in front of her house. Don't put your leaves in front of her house. Don't put your bulk trash in front of her house. Do not place anything in front of her house. Nothing. No thing. You shall attend the Choices Program through eBay. You have a $335 balance with 36 District Court. You shall pay that in full. Court is going to set a review date for June the 10th. The mental health evaluation must have been completed by June 10th. Must have been completed before June 10th. Must be completed. Must be completed before June 10th. Must be completed. Completed. Not scheduled. Completed by June 10th. I'm gonna hold off at this time. There was a recommendation for the 3 days of community service, but I'm gonna hold off at this time because I'm giving her 18 weeks of anger management plus the choices program. Anything further with respect to this matter?
No, thank you, Your Honor.
Your Honor, I would ask the court to reconsider the $35 per month rate at the oversight fees due to the income that's reported in the employment section on page 5, Your Honor.
I don't know. She's working. What do you mean?
Right, Your Honor, but so, you know, just by definition of having been able to use our services, Ms. Brooks is considered.
But everybody that use your services get $35 a month unless I say something else. That the people who use your services don't get a reduced rate for the oversight fees. No,
Right.
She's gonna require a lot of oversight. So no, not right now. I won't reconsider it. No.
Okay, I'm just looking at the rate of pay, the rate of hourly pay, Your Honor. And
I'm looking at it. Said the answer is no. She's not the first person that makes $14 an hour that get $35 a month. She's not the first. And at this moment, the answer is no. I'll reconsider it later to see how she's doing, but based on her ability to pay, well, I mean, we could do an ability to pay hearing, and she could bring in all the money and all her, you know, expenses and things and such, including how much she paid for that taser gun.
And I know she's gonna have to pay more for her, the anger management, because that course is a
Ms.
lot
Stevenson,
longer.
the answer is no.
Your Honor, thank you.
Okay. I'm gonna mail a copy of this order. I'm not. The court is gonna mail a copy of this order to the Stout Street address. Probation is gonna contact Ms. Brooks at the phone number ending in 2689. And if anything, I will convert some of her costs to community service, but I'm not reducing it. She's gonna require a lot of oversight. I can clearly see she's gonna require a lot of oversight. Anything further?
Nothing on behalf of Ms. Brooks. Thank you very much, Your Honor.
All right, you're very welcome. Everyone have a great day and stay safe. Good morning, Deputy.
Good morning.
All right, I see on your screen it says Wayne County Jail Steve Miller, but I don't see a Miller on my docket. Is this a probation violation? I mean, tether violation for when?
Last Friday.
Oh, okay. All right, I'll send the jail to the breakout room.
Thank
you. All right, Mr. Mr. Miller, I might put a couple of things in front of you because I gotta recuperate from that last sentence, so give me just a moment.
No rush at all. No rush at all.
All right.
Like witness and trial.
All right, I'm gonna bring in a couple of people. And then I'm gonna bring in I need everyone to stay muted. Ms. Ritter, your witness. Did you ever talk to your witness on mine?
I did not do it, I just renamed her in a way.
Oh, there she is. All right, this is case number, 214514501. People of state of Michigan versus Lynise and Moss. Defendant is charged with 1 count of assault or assault and battery. Today is the date set for final pretrial conference. Appearance, please.
For the record, Your Honor, Christina Ritter, on behalf of the people, I have a complaint with this present via Zoom this morning. Ms. Lovely, unmute yourself and state your name for the court, please.
Ma'am, please, unmute yourself and state your name for the court, Ms. Lovely.
Amanda Lobley.
Thank you. Ms. Moss, state your name for me.
Lynise Moss.
All right, it has come to the court's attention, Ms. Moss, that you exceed the guidelines for representation by the misdemeanor and felony defender's office, and that you are going to need to retain counsel. I need Ms. Pratt. Ms. Pratt, you're gonna have to make your way downtown. Ms. Moss, the defender's office has indicated that you exceed their guidelines and that you're gonna have to retain counsel. Did they explain that to you?
Yes, Your Honor.
All right, so how long?
How long until I can retain counsel? Sorry, you're going.
Yes, how long will it be? I'm gonna adjourn the case and give you an opportunity to retain counsel.
I will work on it like this week.
So let's adjourn it for 30 days, maybe about thereabouts, do you think?
Sure, thank you, Your Honor.
Let's see, this is March. No, it's not. It's February. Mr. Flanagan, how many do I have on March 15th?
$18.
What about on the 20th?
$60.
Ms. Moss, do you want the 15th or the 20th of March?
Let's say the 20th of March.
Okay, then I'll set it for March the 20th.
Thank you, Your Honor.
And then that's gonna be at 9:01. 9 o'clock for your purposes, but for my clerk, 9:01. And then Ms. Lovely, you are not required to appear that day, but you may appear if you want to. You can appear at every court appearance, but we are noting that you appear today. If you don't appear on March the 20th, then you should contact the prosecutor's office to find out the next court date, okay? All right, anything further at this time?
No, thank you, Your Honor.
All right, then, Ms. Moss and Ms. Lockley, we're all set. You both have a great day. Stay safe.
Thank you, Your Honor.
You're welcome. All right, I'm ready on Pratt and Singh. All right, This is case number 234496701. The people of the state of Michigan versus Dom Sharif, and then it's hyphenated Asa, Sene, S-E-N-E. Defendant is charged with 1 count of assault or assault and battery. And then, oh, yes, and then 02, the people versus, Tielza, T-E-A-I-L-Z-A-H, Pratt. The defendant is also charged with 1 count of assault or assault and battery. Today is the date set for final pretrial conference as to both defendants. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
And Ryan Murad, PA 3665, on behalf of Mr. Dame Sene. Mr. Sene, please state your name for the record.
Yes, Dom Sen.
I'm sorry.
And what's your middle name, sir?
Sharif Hassan.
Thank you. Ms. Payne?
Yes, good morning, Your Honor. Sharon Payne, P 38749, representing Ms. Talisa Pratt, who is present via Zoom. Ms. Pratt, could you please unmute and state your name for the record?
Tielza Pratt.
Thank you. Today is the day set for final pretrial conference as to each defendant. Mr. Moran, how are you proceeding?
Judge, we move for dismissal for complainant's failure to appear.
Okay. Ms. Payne, how are you proceeding?
We also move for dismissal, Your Honor, for the complainant's failure to appear.
Ms. Ritter?
Your Honor, the complainant witnesses in both matters are minors, and the court never required their appearance. And I think the people didn't know that at the pretrial conference that they were minor complainant witnesses.
How old are they?
At the time, Ms. Janiyah Tyner, the complainant Pratt, was 14 years old, and Mr. Daniel Tyner, for Mr. Sene, was 17 years old.
They have different complainant witnesses. Why are they charged together?
Your Honor, it stems from an incident that happened where there were 3 counts of assault and battery because there were 3 different complainant witnesses.
But from a singular incident?
Yes.
Okay. All right, the motions to dismiss are denied.
Judge, in that case, Mr. Sin continues his plea of not guilty and is requesting jury trial.
And as to Ms. Pratt?
Your Honor, in that case, since the motion was denied, my client is requesting a trial as well. And I believe we're requesting a bench trial. Is that correct, Ms. Pratt? Or are you requesting a jury?
Trial.
I didn't hear her, I'm sorry.
I didn't
Trial.
either. What kind of trial, judge or jury, Ms. Pratt?
Judge.
I think she said judge. Did you say judge? I can't.
Yeah.
All right. So the court is going to continue not guilty pleas as to each defendant, and I will set the matters for trial. With respect to Ms. Pratt, Ms. Pratt, you've indicated that you want to waive your right to a jury trial and have the case heard by the court. Is that what you want to do?
Yes, can I do jury, please?
Okay.
Okay. Court continues a not guilty plea on behalf of both defendants. Set the matters for jury trial. I think my next jury trial date is go to August 20th and tell me about that site. Who's doing it?
Sarah Roberts.
I'm sorry, Your Honor, I didn't hear that.
I was talking to my clerk.
Oh, okay, sorry.
And when is their final retrial?
On the 7th.
And it's the defendant, not the defendant. What's the charge?
MDOP as an agent.
I might have to bump them. Who's my jury trial on August the 12th? I may be glad. Okay. Okay. Go back to August 20th. Do I only have that one?
Yes, no, you have 1, 2, 4.
I have 4 jury trials.
August 20th.
All right, let's go to. I want to this one first priority since witnesses are. Fine, let's go to October 1st.
October 1st. One on that day.
No jury trials.
On October 1st.
All right, court is going to set the matter for trial October 1st.
Was that October 1st?
October 1st.
Got it. Thank you.
And the court is going to set a final pretrial conference for August the 30th.
Okay, give me a minute. Okay.
Jury trial is at 10:30, final pretrial is at 9:10. Any pretrial motions need to be filed so that they can be heard by August the 30th. Anything further?
No, thank you, Your Honor.
No, thank you, Your Honor.
Nothing further, Judge.
Then we're all set. Have a great day. Stay safe.
You too. Bye.
The deputy is still present on the screen. Did you all talk to Mr. Evans yet?
No.
Not yet, Judge.
Okay, can the jail go back to the thing is there an issue with Mr. Evans today?
No, Judge, there was no one in the breakout room. If you can send us back, please.
You just have to go with, okay, hold on. All right, Mr. Miller, give me, a couple of minutes on your case and I'm ready. And then,
Sounds good. Thank you, Judge. No.
I'm gonna take just a brief break. Are we ready on, well, it looks like we're ready on Cunningham and Lawrence. All right, I'm gonna take a 5-minute break. I'll be back. Mr. Miller, I'm ready.
Sounds good, Judge. I'm here too. I think
Hold on. Oh, no. Let me bring your client on. You may have to go in and get your client. He's not responding to my attempts to
okay,
bring
I'll
him
go.
up.
I'll jump back in there.
Okay. All right, I'm ready on, Lawrence. Oh, they came out quick, okay. All right, let's see. All right, this is Clyde Richard Lawrence, case number 194563801. Defendant is charged with assault or assault and battery. Today is the date set for final pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
And Ride Marad P83665 on behalf of Mr. Clyde Richard Lawrence. Mr. Lawrence, please unmute your device and state your full name for the record, sir.
My name is Clyde Richard Lawrence.
Today is the day set for final pretrial conference. How are we proceeding?
Judge, we move for dismissal for complaining witness's failure to appear today.
Ms. Ritter.
So, Your Honor, there was a pretrial conference held, and, well, I'm sorry, there was an adjourned pretrial conference held, Your Honor, on November 8th, and the court set a final pretrial conference for today, due to the fact that the complaining witness appeared on a pretrial day, but they were having some technical issues on Zoom. So the court did require their appearance for today's final pretrial conference. And I don't see the complaining witness, Ms. Yvonne Collins, in the waiting room, Your Honor, and I don't have an explanation as to why Ms. Collins is not here. She was required to appear by the court. So at this time, Your Honor, the people will not be able to proceed based on the complaining witness's failure to appear as required by the court.
The court is going to grant defense counsel's motion. The matter is dismissed without prejudice. Mr. Lawrence, we will mail you a copy of the order of dismissal for your record, sir. Have a great day and stay safe.
Thank you very much, man.
You're welcome.
Yes, please.
All right, Mr. Miller, I'm ready for you. All right, this is case number. (234425401), the people versus Toya Lamar Mayberry. Defendant is charged with assault aggravated. Today is the date set for sentencing. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Clay Miller, P 6291, standing in for Attorney Ryan Hill here on behalf of Mr. Mayberry. Mr. Mayberry, please unmute and state your name for the record.
Toya Lamar Mayberry Jr.
Today is the day set for sentencing. The court has had an opportunity to review the pre-sentence report. With respect to the report itself, are there any additions, deletions, or corrections on behalf of the people?
Judge? No, Judge, no additions, deletions, or corrections on behalf of the people.
And none on behalf of defense.
All right. With respect to sentencing, is there any, anything on behalf of the people?
Yes, Your Honor. So, Your Honor, there was a plea agreement with a recommendation for probation, no contact with the complainant witness, Mr. Steve Williams, 24 weeks of anger management, and the people didn't consent to hide in this matter. It looks like Mr. Mayberry was, I believe, 23 at the time of the incident. And looking at the prior criminal history, the people have no objection to hide in this matter, Your Honor. There was a recommendation for probation for a 1-year probationary term, Your Honor. The people would ask the court to adopt that recommendation. There was a recommendation for driving improvement program, Judge. I'm asking the court to actually strike that and not order that at this time because that has nothing to do with the incident at hand. And then as far as page 4, where there's a victim statement, Judge, I don't know if the court remembers, but we weren't here last and there was an incomplete PSI, but the complainant witness did appear and the court did give the complainant witness, Mr. Williams, an opportunity to speak and make a victim impact statement. And I think that kind of went a little sideways. So at this time, Judge, I don't see anything continuing as far as a victim impact statement, just the incident that was reported by Mr. Williams for probation on page 4, and it continues. And then the people don't have any information for restitution, Judge, so the people are comfortable with restitution being set at 0.
He didn't have any injuries when he got hit in the face with the brass knuckles.
And he did, Judge, and then that's the thing, because I mean, the people didn't get an opportunity to get into the restitution. Like I said, the victim impact statement, the day he tried to make the victim impact statement, it kind of went sideways. So the people didn't get a chance to indulge in if there's any restitution. So if we get any information later on, Judge, I'm asking the court to leave that open for at least the first review day to see if there is any medical expenses that Mr. Williams paid out of pocket regarding this incident. And that is it on behalf of the people, Your Honor.
Okay. On behalf of the defense.
Your Honor, similarly, I've gone through this with my client, and we would recommend that the court adopt the recommendation. I would like to say a few good things about my client, if that's okay. He is gainfully employed. He is working there, and this all did stem from a very emotional situation with the client's father, who had passed away at a funeral, and he's got no priors like the judge. He's never done anything like this. He's never been in trouble for anything like this. He does have some traffic stuff, which he's acknowledged, and he's well on the path of taking care of. So I just want to make it known that this won't be an issue going forward with my client. He understands and regrets everything very much so. But it was a very high emotionally strong situation which led to this, and I don't envision this ever being an issue again. So we would recommend, or request rather, the court adopt the recommendation.
And would Mr. Mayberry like to make a statement on his own behalf?
Mr. Mayberry?
Yeah.
You may.
Yeah, if you have a few things you'd like to say, you can. Otherwise, let the court know there's nothing else.
Well, I mean, I said things weren't supposed to happen the way it was supposed to happen. I apologize that things happened where it happened. It wasn't intentionally done on purpose. But I said my dad passed away, and I said, well, y'all. I mean, I made a statement about what was been going on in the past, and I said some things did happen at the funeral. That's the way it turned out, but it wasn't intentionally to go down like that. I said I apologize, and now I'm an adult, I'm own up to it. I got to deal with whatever it is and just handle it, keep it moving. And that's really it.
I'm sorry, but I hate to go out of turn. I just want to bring the court's attention that on continued page 4A, the last sentence reports that Mr. Williams told probation that his insurance paid for all of his medical expenses related to the incident. So restitution will be zero at this time.
Yeah, I did. I actually had it highlighted. I didn't remember it. I mean, I wasn't looking at it when I think, but I had it highlighted, so thank you.
Sorry about that.
Listen, okay, Mr. Mayberry, first let me say, I'm sorry for your loss, with the death of your, father. And it sounds from, you know, what I'm reading that perhaps your uncle has been holding on to, you know, some things, I guess, that he was accusing your father of for a long time, and perhaps he let it show up at the funeral. I'm not quite sure, you know, why he chose to show up that day. And I'm gonna tell you, Mr. Mayberry, really the reason that I'm giving you what I'm gonna call a pass, and I'm not going to sentence you perhaps as harshly as I probably would, is because it was your father's funeral and you were probably grieving, and then somebody show up and they talking down about your dad, and you know, whether, I don't know if his allegations are true or not, but I don't know what he would have wanted to accomplish at the funeral. I do note, just based on his victim impact statement, he appears to still be very angry and very accusatory of the system, very untrusting of the system. If my memory is correct, I believe that is the one of two people, because I think I did it to two people that I interrupted during their victim impact statement, because they were, you know, like implying that I was on the take. And you know, I don't take kindly to that, because I'm not on the take. It's not enough money that people can pay me to cause my integrity to be in question. So but I understand that whatever his issues are, he's very, you know, adamant about those things, and perhaps it wasn't the right place for it to show up. Nonetheless, that's why I'm also gonna give you a pass, but, because if my niece or nephew punch me in the face, I promise you, I'm the one that's gonna be the defendant. Yeah, I am. If they punch me in the face, I'm gonna be the defendant, because I'm gonna go overboard. Like, I know the law, and it says that a person can defend themselves and use a reasonable force necessary. I'm probably not gonna use the reasonable force necessary, because I'm gonna feel like this my niece and nephew, and then I'm gonna just go way overboard. Like, I know I would. So.
Yeah, I agree. I understand.
Yeah, but you know, I also would never say anything like this at my niece or nephew's parents' funeral. So nonetheless, I am gonna accept the recommendation for a 12-month probationary period. I also will accept the request for HIDA. So from after today, your case will be suppressed. I'm gonna set a review date for the halfway point, 6 months. And then at this review date, if you have completed the terms and conditions of your probation, then you'll be eligible to be discharged early from probation. So you have an opportunity to only do 6 months on probation if you go ahead and do what the court is gonna order you to do. So what? The halfway point is in August the how many do I have on August 13th? Actually, let's move it to August 15th at 1:30. How many do I have?
August 15th, nothing that day.
All right. August 15th at 1:30. That's the halfway point. The final review, if we get that far, is February the 11th of 2025. Court is going to order the following terms and conditions. You shall not violate any criminal law of any governmental unit. You must not leave the state without consent of the court. You must notify probation immediately of any change of your address, phone number, or employment status, and you must report to probation on a monthly basis. You're going to pay $210 mandatory cost, a $150 fine. Court sets restitution at $0. $35 per month supervision fees for the total 12 months is $420. A $50 pre-sentence investigation fee. The total fines, costs, and fees are $800. Did I add that right? $830. Let me make sure. Yes, $830. Additionally, you shall not use or possess any illegal substance. No marijuana without a valid medical marijuana card. No opiates without a valid prescription and letter of explanation from the doctor. No driving without a valid driver's license. 6 weeks of anger management. Choices through eBay. No contact with the complaining witness. Pay any outstanding tickets that you have with 36th District Court. Now, Mr. MIBryant, let me ask you this question. Because I'm looking at page under education, and they say you was getting kicked out of school. You've been fighting for a long time.
No, I wasn't fighting. I said I did 9th grade hearing for it. 10th grade year came around, and I was playing around in 9th grade, and I said when 10th grade came around, they was like, "Don't come in here doing the same thing you was doing last year." So I did like 3 months of the 10th grade, and then an incident popped off with some people that I knew, and they put all of us out. So I did the rest of that homeschooling online. I forgot the name of the school that I was with. I did that for the rest of that 10th grade year, huh?
Did you finish the online school? You didn't. It says that you don't have it.
Huh?
This report says you don't have a high school diploma or GED.
No, I don't.
Well, I want you to go back to school. What you trying to do with your life?
Well, I mean, like right now I work all day, so I want to go back and finish it. I just gotta say I gotta squeeze it in. Like I said, right now, what's going on? I said I got a lot of stuff going on, and this is an add-on. And by me working all day, opening and closing, I had to squeeze it in. But I know I can. I just gotta do it.
It says on here it says mechanic and then / office work. You work
collision. Huh?
You work at the collision shop.
Correct.
Do you have a certification?
No, ma'am.
You don't want to get it?
No. I mean, I want to, but I mean, I know I can go further in life if I get one. But I said the way it was going on now, I got a lot of stuff going on. So it's something I will want to do. I can go further in life with it, and I could probably go to a different place to work and get something serious going on. But for what's going on for me now, I said I want to squeeze it all in. I want to do it, but I said it's a lot of stuff going on. So I want to jump off into it right now until I put catch up with what I got going on.
Oh, well, you're going to have to jump off into it because I want you to. You're too young not to have some type of something. GED, high school diplomas, mechanic certification, a certificate, something. So you're gonna have to do it. I want you to do it. I want you to sign up at least for the adult education program. or look into some type of, mechanic certification program. I know it's a lot, Mr. MIBryant, and I'm not, I want you to do it though. You might, yeah, let's just work towards it, okay?
No, sir.
All right. I'm not gonna order the aggressive self-realization program at this moment, nor am I gonna order these up things. I think they were just mistakes, because they don't even make sense. I'm not gonna order any outpatient treatment. He didn't test positive for anything. At this time, I'm not gonna order the community service either. And then, your license is suspended, so don't drive. And you have to, I said pay all outstanding tickets, but you need to get on a payment plan. Cause you owe a lot, so you just gonna have to get on a payment plan. You probably won't be able to pay it all at one time. All right, anything further?
No, thank you, Your Honor.
Nothing further from us, Judge. Thank you.
All right, then we're all set. Mr. MIBryant, we're gonna mail you a copy of this order to your Justin Street address, and probation is gonna contact you at the phone number ending in 6093. And then, make sure, I usually don't go live in the afternoon, but just put that case at 12:50, so I'll know it's later. All right, and we're all set. Have a great day and stay safe.
Thank you, Judge. You as well.
All right, thank you. I'm ready on Evans. Did you send me something? All right. All right, I'm ready on Evans. This is case number, 234523301, the people versus Steve Evans, and the defendant is charged with retail fraud, second degree. Today is the day set. Well, Mr. Evans has been brought to the court on I think, is this a tether violation? Tether violation. All right, appearance. Oh yeah, appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Mr. Steve Evans. Mr. Evans, sir, please say your full name.
Steve Evans.
Oh, you're not supposed to go to the BP gas station? All right, this says they had 2 exclusions on alerts, and, you're not supposed to go to the BP, Ms. Stevenson.
So I think the court already heard part of this, Your Honor, wherein he was in the parking area of one location, looking for his wallet. And
Where? He can't be in the parking area.
but I think you already heard that part. There was another one where he was, it's a little confusing. I'm sorry, Judge. Okay, so no, he wasn't at the, it's saying that the police went to the BP gas station to make sure that the complaining witness had not had any contact. So the BP gas station,
let me read it again, hold on.
okay.
He's charged with retail fraud and assault and battery. So retail fraud is a retail location. Then it says, he made the subject, okay, subject was located, in place, search, okay, after place subject, made a house stop at the victim's house. So he went to the victim's house, they spoke with the victim, and they said he was all right. Then it said, I made a business stop. Oh, and then they said he was all right. Okay, so what's the tether violation?
That's what I'm trying to figure out, because I can't see where he was that he wasn't supposed to be. Those 2 locations, at 13330 Dexter, the BP gas police went there to check with the complaining witness. And then they went to that Waverly address to check with the complaining witness. I don't see unless I just can't see it. I don't see an allegation of Mr.
It
Evans
has,
having been at either of those locations.
it said he had 2 exclusions on alerts, but it don't tell me what that was. I don't know what that is. And so therefore it's insufficient.
Move that the tether violation be dismissed. I'd ask the court to consider removal of the tether at this time, Your Honor. Mr. Evans is living at a location outside the city. Understand he has no capious history in this case because it hasn't even made it to pretrial yet. And Mr. Evans knows he has to come to court and stay away from the complaining witnesses and the locations as he was advised at the arraignment.
I am going to dismiss the tether violation. However, I'm not going to remove the tether at this time. And if the sheriffs, they need to do better putting in specific information about what tether violation was. But at this particular time, because they're saying he had 2 exclusion alerts, I'm gonna keep the tether for now, but I'm probably gonna change it at the pretrial. When is he scheduled for pretrial?
I just closed it.
March 6th.
March 6th, so, ma'am, don't lay down ever again while you're waiting on court. Don't do that. Don't do that. Miss Miles, I'm gonna send, oh no, Miss Miles, you the one here on the wrong day.
Right.
Ma'am, you're not on the docket until, the 16th, Miss Miles. We'll see you on the 16th. All right. With respect to the tether, also, I'm gonna remove the curfew, though. I know the jail doesn't like for me to do that, or to tether people, I don't know, but I'm gonna remove the curfew. I'm only gonna keep the 2 exclusionary zones, and then I'll address the tether again, at his pretrial, and if he has some exclusion. Okay, well, you see what happens if he go into the exclusion zone. So, but the request is not specific enough for me, so I'm gonna, dismiss the tether violation.
Thank you, Your Honor.
You're welcome.
Thank you, Your Honor.
You're welcome. All right, well, I don't know how long the line is for another tether, but hopefully you'll get out of there today.
Your Honor,
I'm sorry.
the actual hold for the tether is like 3 to 5 more days, and I've been incarcerated on and off for like since January 9th.
Okay, well, stay out the exclusionary zone.
Okay, all right.
People say you don't the city, so just don't come down here near that gas station.
Okay, all right, thank you.
Well, I'm confused about Mr. Floyd. Didn't I see him like that? I'm ready on Cunningham. And then I'm confused about Floyd. Was he over? Ms. Dixon, didn't I see Floyd the other day?
You did, Your Honor, in the afternoon. I can't remember if it was Wednesday or Thursday, but he had to come back, hopefully, so that Ms. Bryson would have the opportunity to review his my argument that he had been in compliance, has come into compliance.
Okay, let's contact him. Okay, I'll put you, do you want him in the waiting room or in the breakout room?
In a breakout room, please, Your Honor.
All right, Mr. Floyd, go to breakout and we'll call Ms. Bryson. All right, I'm ready on Cunningham and then I'm ready on the trial. This is case number 20-448-0501, the People versus Tina Nicole Cunningham. Defendant is charged with 1 count of she charged with? Molesting or disturbing workers. That don't even make, what, who wrote the name of the charge? Okay, and today is the day set for a final pretrial conference appearances, please.
For the record, Your Honor, please speak over there on behalf of the people.
And Ryan Murad, P83665, on behalf of Ms. Tina Cunningham, who's present on Zoom. Ms. Cunningham, please unmute your device, ma'am, and state your full name for the record.
Tina Nicole Cunningham.
All right, today's the day set for final pretrial conference. How would you proceed?
Your Honor, I'm moving for dismissal for complaining witnesses' failure to appear. I'd like the court to, I guess, entertain my argument here with regard to the statute, that it seems that requires some sort of worker to be dismissed or to be annoyed, molested, or threatened or intimidated. That worker, according to the discovery, works at Landmark Properties. I don't see a member of Landmark Properties or a representative on their behalf. And I move for dismissal for their failure to appear today.
Ms. Ritter.
So, Your Honor, I believe that the pretrial conference, the court did, I don't think the court required, but the court did.
I wasn't here, but Judge Garrett, I don't know, I can't. Judge, it looks like, is this Judge Garrett?
Judge Garrett was presiding, yeah.
All right.
So the court inquired if the people will be able to proceed based on the nature of the charge, Your Honor, and I did not see a complaint witness on behalf of Landmark Property management this morning, Judge, and I don't have an explanation as to why the complaint witness did not appear. So at this time, Your Honor, the people will not be able to proceed based on the representative on behalf of the complaint witness to appear for today's final pretrial conference.
Today is the day set for final pretrial conference. People have indicated that they cannot proceed without the complaining witnesses' cooperation. The court is going to grant defense counsel's motion and dismiss the matter without prejudice. Ma'am, we will mail a copy of the order of dismissal for your records. Have a great day and stay safe.
Thank you, Your Honor.
You're welcome. All right, I'm ready. Where's Ms. Houston?
Can maybe take her position in breakout room.
Well, she heard me say I was be ready for the trial, so why she went in the breakout room with Mariah? I'm ready. Yeah, go take her position in the breakout.
Yes, Your Honor.
So what's the situation with the competency hearing from me? It's at 8:30. Did I schedule that? Are they discussing?
Wasn't on the list this morning.
You said you saw them on the list?
No, they weren't on the list. Set for competency hearing back in December 11th.
Oh, wait, yeah, I was back on December 9th. Can we check to make sure they're not?
Yeah, I'll call.
I have about 5 minutes. Okay, I appreciate that.
Okay.
It's just the ones that were in here.
Mr. Mariah, you put that plus sign on there. You have not talked to Ms. Bryson yet. I need y'all to go back in the breakout room until Ms. Bryson, I'm gonna bring in Ms. Bryson. You need to talk to Ms. Bryson.
Okay, no problem.
Hold, I'll let her in out of the breakout room, out of the waiting room. Then you need to talk to Ms. Bryson first. I'm gonna put your client back in the, thing because I already know what he's saying. We need to know what Ms. Bryson is saying. So let's put you and Ms. Bryson in the breakout room. So Mr. Murad, you can go to number 10 and talk to Ms. Bryson.
Yes, Judge.
All right. All right, that was quick. Does that mean your client is lining up with Ms. Bryson? I know it. Go back and talk.
No, he's good. We're ready to go.
Oh, he's okay. He's okay. Okay, well then let me bring him out. Oh, you didn't go yet. Let's see. Okay, because the last time that's not the report I had. Whew, I'm burning. Y'all got it? Oh my goodness. All right, it looks like we're ready on Floyd. And this is case number 184609601, the people of the state of Michigan. Oh, I forgot. That quick and that easy. All right, now we're ready on Floyd. I forgot. And nobody was gonna say nothing to me. Y'all just sitting there and watching me fall. They're sitting right there, directly by the court, and she didn't even say, "Judge, you don't have your court reporter." She don't even, oh, you're not the co-host on Zoom or in person. This is case number 184609601. The people of the state of Michigan versus Kenneth Raymond Floyd. Defendant is charged with operating while intoxicated. Today is the date set for review. Appearances, please.
Good morning, Your Honor. This is Tracy Bryson on behalf of probation.
And good morning, Rad Marad, P836665, on behalf of Mr. Kenneth Floyd, who's present on Zoom. Mr. Floyd, please state your full name for the record, sir.
Kenneth Raymond Floyd.
All right, today is the day set for review, and I don't necessarily remember what happened last time. I just remember that Mr. Floyd was here recently. I don't have my notes from that day. They might be upstairs though, in my chamber. But I'm told that that Mr. Floyd was saying one thing, but it was different from Ms. Bryson's report. And so apparently I adjourned this today so that Ms. Bryson can give me a good report. I mean, to see if it was lining up with what Mr. Floyd was saying. So, Mr. Murad, you want me to go to Ms. Bryson first or you? Or what?
Yes, Judge.
All right, Ms. Bryson.
Good morning. Yes, Mr. Floyd, he emailed me proof of his highway safety class that he completed that. He also emailed me proof that he completed his victim impact, and the video consequence is online, and he did elaborate with me what the video was about. So they don't give a completion of that course for that, but he did let me know that he completed that video consequence, and he's been doing his testing and they've been negative.
Okay, I keep saying I'm going to create a test. I keep saying that I was going to create like a quiz and give it to probation so that you can confirm that the person did watch it. Like,
okay, that would be great, Your Honor.
Yeah.
That would be great.
They watch it at the VIP, I think. I think they're required to watch it at the VIP.
I think so. Yeah, I think so too. So, but I do know that they don't like you said, it's online. But I think when they do the VIP with Mr. Rice, he does the consequence video as well. All right, so that means Mr. Floyd is, where did I put him on?
April 12th.
He had failed to report and stuff, and I already addressed that. So when did I put him on probation?
April 12th, 2023.
For 12 months?
Yes, he was scheduled for discharge next on April 10th. He'll be scheduled for discharge.
All right. Well, I think we brought him back today so he can get off early. And since he looks like he's done everything, then we're gonna go ahead and discharge.
Yes, ma'am. And I can do a proper discharge for him today.
All right, great. Okay, great job, Mr. Floyd. We're gonna go ahead and discharge you from probation with improvement. Close your case out. You're done with me and Ms. Bryson, okay?
Thank you.
Oh, wait. Did you pay the full amount?
Yes, ma'am.
So we owe him he was scheduled for discharge in April. We owe him 2 months of oversight fees back then. Did I charge him the regular price for the oversight fees?
$420.
So we're gonna refund you $70. We're gonna send you back $70, okay?
Okay.
All right, so if you don't get it in about 4 weeks, call Mr. Moran.
Okay.
And ask him, run me my money, Mr. Moran. No, just let him know you don't get it in about 4 weeks.
Okay, it's coming to address, I mean, on file, right?
Yes,
Okay.
yes. All right, then you're all set. Have a great day. Stay safe. Thank you, Ms. Bryson.
Thank you, Your Honor. Have a blessed day.
Thank you.
Thank you. Tell Ms. Stevenson 5 minutes is up. All right, Mr. Murat, I don't know who that phone number is in the waiting room, but I'm not. Do you want me to let him to talk to him?
I mean, we can, yeah. Why not, Judge? Let's do it.
Yeah, you can. I'm going on the trial. I'm getting ready to do a trial. I'm sending the phone to number 2. You can go in there and see who they are. All right. Now take off your coat. Okay, this is case number 22448-9401, the people of the state of Michigan versus Kaylin Denise Coker. The defendant is charged with 1 count of assault or assault and battery. Today is the date set for trial. Appearances, please.
For the record, Your Honor, Christina Berger, on behalf of the people, I have my officer in charge, present in the courtroom, standing behind me, and she put her appearance on the record.
Yes, please.
Detective Yvette Garcia.
I didn't hear you.
Detective Yvette Garcia.
Thank you.
And for the record, Your Honor, Janice Stevenson appearing on behalf of Ms. Kaylin Coker. Ms. Coker, ma'am, please tell the judge your full name.
Kaylin Denise Coker.
Thank you. Today is the day set for trial. Are the people ready to proceed?
The people are ready to proceed, Your Honor.
Is the defense ready to proceed?
Defense is ready to proceed, Your Honor.
Are there any preliminary matters before we proceed?
Yes, Judge, at this time, the people, motion for order of sequestration with the exception of my officer in charge, who's present in court.
Ms. Stevenson?
Concur in the motion for sequestration, Your Honor.
All right, then the motion for sequestration is granted with the exception of the officer in charge. If there's anyone in this courtroom that will testify today or in the future on behalf of the people or on behalf of the defense, you must leave the courtroom. Okay, nobody moved. There are 2 individuals in the courtroom. Anything further?
One last thing for the people, Your Honor, there was a stipulation to some photos of the complainant witnesses injury that defense counsel is stipulate to. People are offering evidence that exhibit 1 through 3.
Ms. Stevenson?
Stipulate to us, photographs, sure.
The court will receive people's exhibits 1 through 3.
Thank you, Your Honor. Nothing else.
You know, actually, so can I, so my stipulation is not that these are injuries that this complaining witness received.
Of course not, Ms.
Okay.
Stevenson. That would be, you're stipulating that the photos are admissible and admitted and that they are pictures of the complaining witness.
Yes, that's it. Thank you so much.
Oh, so, okay. All right, then. Okay. Madam OIC, you can be seated. Okay. As well as defense. Will there be any opening on behalf of the people?
There will be, Your Honor.
All right. Well, let me ask this question because I am live streaming today. How many witnesses on behalf of the people? You can be seated.
1, Your Honor.
All right. And any witnesses outside of whether your client will testify on behalf of defense?
Possibly 1, Your Honor.
And are they present in the hallway?
Yes, Your Honor.
Please go admonish your witness because the only, well, both of them, because you get ready to do an opening statement, that they are prohibited from viewing on the live stream. Just let them know it's a sequestration order.
Yes, Your Honor.
You got stuff up here for me to sign. That's not here. What's this? Well, finally, at least it's working well in advance instead of the day of. I gotta see about everything. Why is he on? Why is he? Why he ain't on it?
Let me see my doctor. Is he scheduled today though? Why didn't he come first today? Mr. Moran, I don't get here. Let me see. Well, hold on one second. Let me tell Mr. Moran if I'm letting him clog up my doctor tomorrow. Oh, Ms. Dixon.
I'm not leaving, Judge.
I know you're not leaving because you're in the middle of a trial. Did y'all hear her say I'm not leaving as she walked out the door? I love all of my team, prosecutor, defense attorney. I just love them all. Ms. Dixon, what I was gonna say is, can you call these two people that's scheduled for tomorrow afternoon and tell them, ask them to come in?
Okay.
You can reach them.
Yeah.
Mr. Murad, I suppose your client who's supposed to be here today, at 9:06 and called in on the telephone after 11. I suppose that I won't issue a warrant for his arrest as I had already put a C next to his name, and I will allow him to come in person only. Listen to my word. In person only tomorrow at 9:06. In person only.
Well, Judge, I'll let him know right now.
I got a message and an email from Shakira Strong. One of her children was requested. I got that.
Okay, well, tell her to send us proof of that when she rushed to the emergency, and then I'll address her.
Okay, thank you.
All right, the people may proceed.
Thank you, Your Honor. Your Honor, one.
And Ms. Ritter, Ms. Stevenson, for your records, for your clients who are gonna try to say that they tried to log in, at 11:46, I'm locking the room. At 11:46, okay?
Thank you, Your Honor.
You're welcome. The meeting isn't locked until 11:46. Okay, Ms. Ritter.
Thank you, Your Honor. So, Your Honor, on May 13th of 2021, there was unfortunately a repass of a family member. And this repass was on Mount Elliott in the city of Detroit. And the complaining witness, the necessary witness, actually was in attendance because the necessary witness is the daughter of the person who passed away. Now, Your Honor, this case is quite interesting because that the court will not be hearing from the victim in this case, the complaining witness in this matter. The court will actually hear from the mother of the complaining witness, Ms. LaToya Grant, who will testify to the court as to what happened on May 13th of 2021. And what happened was there was a repass for a funeral, Your Honor, and the necessary witness, Ms. LaToya Grant, and the complaining witness, her daughter, her 2-year-old daughter, Michael Bass, were in attendance. And the testimony from the necessary witness will be that she was at the repast and she came into contact with her sister. Her and her sister did get into a verbal altercation which turned physical at the repast, unfortunately. And during the physical altercation between the necessary witness and her sister, the defendant came up to the complaining witness, the 2-year-old daughter of the necessary witness, and hit her in her face, causing swelling on the left side of her face. So the court will hear the testimony from Ms. Grant, who will tell the court what happened on that day. And I'm asking the court to listen to this testimony because, again, Judge, this is quite interesting for the people to bring forth this case because we're not hearing directly from the complaining witness. You're hearing from her mother who witnessed what happened to her. And I want the court to pay attention to that testimony. And I want the court to get a glimpse of what happened on that day at this repast, Your Honor. And the court will see the photos that will corroborate the story of the necessary witness, Ms. Grant, as to the injuries sustained by the complaining witness, 2-year-old Michael Bass. And Your Honor, it's important.
And I apologize. Are you saying Michael or Micah?
Micah.
Thank you.
You're welcome. And Judge, again, it's important to hear this testimony as the people will bring forth the evidence through this testimony and the photos to this court. And Judge, I just want the court to think that, again, this is coming from an eyewitness, a necessary witness on behalf of the people. And the complaining witness, due to her age, who was 2 years old at the time, can't tell this story to the court So I want the court to listen to her story through her mother, Ms. Grant. And once the court hears the testimony from Ms. Grant and see the photos that will be admitted as people's exhibits 1 through 3, the people are hoping that the court comes back with a guilty verdict of count 1 assault and battery. Thank you, Your Honor.
All right, any opening at this time on behalf of the defense?
Very briefly, Your Honor, we believe the evidence is gonna show that the complaining witness is not gonna be able to testify credibly as to what did or did not happen to her, excuse me. The necessary witness is not gonna be able to testify credibly as to what did or did not happen to her daughter, Micah Bass, because the necessary witness was engaged in a fight that she started. We believe the evidence is gonna show that this is a kind of messy situation, Your Honor, siblings coming to know each other at the time of the passing of their father, didn't know each other before that, and stuff breaks off. But we believe at the close of the proofs, the people will have not been able to sustain their burden of proof beyond a reasonable doubt that Kaylin Coker did anything, even saw Micah Bass at this incident, Your Honor, and we're gonna ask you to find Kaylin Coker not guilty.
All right, and people may call their first witness.
Thank you, Your Honor. At this time, the people would like to call Latoya Grant to stand, please.
Thank you. Do you swear or affirm that the testimony you're about to give the truth, the whole truth, and nothing but the truth? So help you God? Yeah. All right, thank you. Ms. Rear.
Thank you, Your Honor. Good morning, Ms. Grant.
Good morning.
Ms. Grant, there's a microphone in front of you. It does move up and down, so if you need to adjust it, that's fine. Just make sure you keep your voice up because the court needs to hear you, and the court reporter is taking notes, okay?
Okay.
Okay. Can you state your full name for the record, Ms. Grant?
Latoya Grant.
Thank you. And Ms. Grant, I want to take you back to May 13th of 2021. Do you recall that day?
Yes.
Okay, and where were you on that day?
At a repast for my father.
Okay, and where was this repast located? Do you recall?
Mount Elliott, I believe that's the street. I'm not sure.
Okay, is that within the city of Detroit?
Yes.
And is it within the county of Wayne?
Yes.
Okay, and what happened, when you first arrived at the repast?
We were setting up for the repast after my father passed. A fight broke out. I seen Kaylin open hand smack my daughter in the face.
Okay, let me just stop you right there. We're gonna back up just a little bit, Ms. Grant. So you said that you were at the repast, well, you said we were at the repast setting up. Who is we?
Family, my family, we were setting up the food for the repast.
Okay, and what you testified that a fight broke out. Who was engaged in this fight?
Me, myself, Sharon and Caitlin.
Okay, who's Sharon?
My sister.
Okay, and is that, when you say your sister, is that your biological sister?
I just met her for the first time. We have the same father.
You have the same father?
Yes.
This is your first time meeting her?
Yes.
Okay.
No, I first met her when my father passed. That was my first time meeting her. When he died at his apartment, that was my first time meeting her.
Okay, so prior to the funeral arrangements, have you known your sister?
No.
And what's your sister's name?
Sharon. I have like 5 other different sisters. So
Okay,
what we're
so
talking
you're
about is
talking
Sharon.
Okay, and why did this argument break out between you and Sharon?
To be honest, like, I don't know. I guess I can't answer that because I don't know her. We had just first met. I don't know if it's grief or what. I can't answer that. I don't know.
Okay, so when you say a fight, was it verbal or physical?
It was physical.
Okay, and do you recall, where in the venue were you and Sharon fighting?
It was like the back of the, hall, they have a hall, like in the middle, it was like an aisle middle that we were fighting.
Okay, and was there anyone around at the time?
Yes,
Do you recall who was around when you were fighting Sharon?
other family members, my sister, my brother, I had a couple cousins there, kids.
Okay, and do you recall how long the fight lasted between you and Sharon?
I can't even say no.
Okay, so what happened during the altercation between you and Sharon?
We were fighting.
Okay, what happened next?
We were fighting, and I seen Kaylin open hand slap my daughter.
Okay, so the person you're referring to, Caitlin, do you see them in the courtroom today?
Yes.
Can you point that person out and describe what they're wearing?
She black and she has glasses, smiling.
Okay, can you describe anything else about the person you're referring to? Okay.
No, she has on a black sweater, she has glasses, she has her bun, kind of in a bun.
Judge, may the record reflect identification of the defendant, Kate Coker?
Now that she gave you that additional information, yes.
Thank you.
The record will reflect the identification of Caitlin Coker.
Thank you, Your Honor. And where was Ms. Coker standing during the altercation between you and Sharon?
So, Caitlin was engaging in a fight with my other sister, well, she's not here. I don't know if I can say her name, Judge or not. My other sister, that's on, we have the same mother.
Okay.
So she was engaging in a fight with her.
And where were they fighting?
Like literally, we were fighting right here and they were like in front of us.
So they were in front of you. So
yeah.
Could you see her from where your
Yes.
position in the fight?
Yes.
Okay.
Please let the prosecutor finish her question completely before you answer. What is your question?
Could you see them where you're standing while they were fighting?
Yes.
Okay. And what happened during Ms. Coker and your other sister's fight?
Someone broke them up.
Okay. And what happened after that?
After that, it was still a fight between Sharon and myself, and they were trying to break us up.
Okay.
And I see Caitlin, my daughter was standing right there, and she opened hand and smacked my daughter.
Okay, when you say my daughter was standing right there, where was she?
In the aisle, standing like looking, so we were fighting.
Okay, how far would you say your daughter was away from you?
Like, I could say, like where you live.
So between where I'm standing
Yes,
and
yes.
you're standing, that's where your daughter was standing?
Mm-hmm. Yes.
Okay. And what happened after you witnessed Ms. Coker hit your daughter?
I stopped fighting Sharon and I went towards Caitlin and I swung on her. Yes, I did.
Okay. And when you, let me just go back just a little bit. So did you see her hit your daughter with an object?
No.
Well, how did she hit her?
Open hand.
Okay. And where did she hit her?
In her face.
Okay. Do you recall what side of her face?
No, I don't recall what side.
Do you recall where on her face?
Around like her face, her eyes, like right up in here.
Okay. And what happened after you went towards Ms. Coker and started to fight her?
We were broken apart and my brother got her and escorted them out of the building, the hall.
Okay, when you say he got her, who are you referring to?
Caitlin and her mother, which is Sharon.
Okay. And what did you do next?
I called the police.
Okay. And do you recall how long it took police to come to your location?
It wasn't that long, probably like 15, I don't know, about 15 minutes. It didn't take that long for them to come up to the hall.
Okay, and did you stay at the hall the whole time waiting on the police?
Yes.
Okay. And when the police arrived, did you speak with the police?
Yes.
Okay. And what happened after you spoke with them?
I let them know what had occurred, that's all, at the revenge. And they made a report, and they told me to follow, gave me a court number, and that was it. I mean, a report number.
Okay, did you speak to the police after the day of the incident?
What you mean? Yes, I did.
Okay. And do you remember or recall what that conversation consisted of?
No, I remember the detective came to my home.
Okay.
Like the next day, I believe.
And what, do you recall what happened when they came to your home?
They came and saw Micah, which is my daughter, and made a report and had me on recording.
Okay, and do you recall how long? Well, strike that. Do you recall what day that was prior to the incident, or I'm sorry, after the incident?
I believe it was like the next day, if I'm not mistaken.
Okay, so that's when the police came to your home?
Yeah.
Okay, did you give the police anything regarding your daughter's injuries?
Oh, pictures.
Yeah. Okay.
Yeah.
And may I approach your honor?
You may.
I'm sorry, Judge, may I approach you, man? So, Ms. Bryant, for the record, I just handed you some documents. I just want you to look through those documents and put them face down when you're done. So, Ms. Bryant, the documents I just handed you, do you recall or do you remember what those documents are?
Yes.
And do you recognize those documents?
Yes.
And what are those documents?
Photos of my child being hit.
Okay. And are those the same pictures that you submitted to the detective and or the police?
Yes.
Okay, and have those pictures from your knowledge been changed, altered, depicted, or filtered in any way?
No.
Okay, Judge, at this time, the people would like to publish people's exhibits 1 through 3, the evidence that they already were stipulating to in a minute, I believe.
Well, I guess the objection I would have is that in response to the people's question, Your Honor, the witness indicated that these are pictures of her child being hit. And that's not depicted in these photographs.
Okay. Clarify that. Yeah. Ms. Brent, those photos, you testified that there are photos of your daughter being hit. Can you clarify what you mean by those photos?
I mean that these are pictures that you're seeing in my daughter's face is swollen by being hit by Caitlin overhand.
Judge, at this time, the people move to the people's exhibit 1.
What? I mean, can we just, those are not photos of her daughter being hit. So are those photos of her daughter's face as a result of being hit?
I think, is that what she said? I thought that's what she said.
Not really.
Okay. Ms. Grant, I'm sorry, Judge Mount. Continue. Ms. Grant, what are those a picture of?
These are pictures of my daughter being hit by Caitlin. She keeps saying being hit, and I'm certain that there's no one hitting her daughter in the picture. I mean, just ask us to hold on, ma'am. Can you maybe ask a more specific question so she can answer it and then you publish?
Yes, Judge. Are those pictures of the injuries to your daughter in those pictures?
Yes, these are pictures of the injury that was caused by Caitlin hit my daughter. Any objection to being published to the court? All right, you may publish these once.
Judge, may I approach?
You may.
Judge, may I have one more?
You may.
Ms. Grant, prior to the funeral arrangements for your father, have you met Ms. Coker before?
No.
Did you have a relationship with Ms. Coker prior to the funeral arrangements for your father?
No.
Okay. And are you related to Ms. Coker?
Biology, yes.
Okay, what's your relationship to Ms. Coker?
She's my niece.
Okay, and did you give Ms. Coker permission to hit your daughter on that day?
No.
And how old was your daughter at the time of the visit?
2.
Okay, and from your knowledge, did your daughter give permission for Ms. Coker to hit her?
No.
Judge, I have no further questions.
Cross-examination.
Thank you, Your Honor. Okay, so Ms. Grant, do you recall whether you arrived first to the venue where the repast was, or when you got there, was anybody else present?
Yes.
Who was there when you arrived?
We all kind of like was there, everybody, Caitlin, Sharon, my sister, Alicia, my brother, Albert. The sheriff, she was setting up for, she cooked all the food for the repast.
Okay. Okay, so is it safe? So did you, when you got there, did you already see the person you called Sharon?
Yes.
Did you already see Ms. Coker?
Yes.
Okay, what were they doing when you, as you arrived?
Sitting down, walking, well, Caitlin was sitting down, Sharon was coming in and out.
Okay, were they helping to decorate it all or anything like that?
They had no decoration.
Okay, they weren't putting any tablecloths on or?
Not that I know.
Okay, all right, so is there, when you arrived, you, the two of you, you and Ms. Sharon, do you have any conversation at all?
Yes, we did.
Okay, did you say anything to her?
I said, why is she here?
Okay, all right, were you surprised to see her there?
Yes.
Okay, did you want her there?
No.
Okay, so if we could, somebody usually is responsible for putting on the repacks. Were you responsible for that?
Yes, me, my brother Albert, and the sheriff.
Okay, all right, so, you financed all of that?
I'm sorry.
Did you pay for all the repasts and all that?
Well, I pay half, my brother Albert paid, and the other sheriff as well. We went half on it.
Okay,
Yes.
kind of part of, out of some insurance proceeds or something
Sure,
like that?
objections are.
Goes to the witness credibility. It'll actually, it's gonna show motive for the fight that took place, and then it is gonna.
No, ma'am, don't answer. I don't know why the motive for the fight is relevant to me at all, period, either. I'll allow it a little bit, but it's like a real short string.
Okay.
I agree that I can't see where it's relevant right now.
Okay, all right, so did you pay for, part of the repass out of some insurance proceeds?
No.
Okay, all right, so, how many of your family, who's present when Micah gets hit? You remember, how many people?
I would say about 10, but it was just it wasn't many people there. Probably about 10, I'll say, a good 10.
Okay, and so the people present would have been, you said your sister, not Ms. Sharon, but another sister.
I had another sister, the sheriff, who did the cooking.
Okay, so how many?
There?
Yes, please.
Okay, the sheriff, Sharon, Caitlin, my sister Iquisha, my brother Albert, the kids, Micah, my sister's fiance at 8, LaShera's mom, Linda, then LaShera's couple of her friends that came to support her. I don't know their names.
Okay, all right, so there were 2 children present about?
I could say about 3.
About 3 children? Okay, is Micah the oldest of those children, the youngest?
No, my baby was the youngest.
Okay.
2.
Okay, all right, so LaShera, Iquisha, and Albert, those are Micah's aunt and uncle.
Yes.
Aunts and uncle. Okay, so are they, like, when this fight jumps off, what are they doing in terms of what Micah's, are they looking after Micah or?
I can't. It was so chaotic, ma'am. My brother Albert did try, he got Caitlin and Sharon out of here.
Okay,
Yes, he did.
okay, all right, but nobody gets the baby?
My baby was, my daughter was standing there looking at us fighting, ma'am. She was, you know, bunch of grown people fighting in a repast. She was standing there, I looked exactly at my baby while I was fighting Sharon.
Okay, so the fight between you and Sharon, how long does that go on?
I would say a good 20 minutes. It was, yes.
So you're fighting, you and Sharon are fighting for about 20 minutes, and Micah sees this happen?
She's standing right there, ma'am.
Okay, so anybody try to get her and get her away from
I
that?
didn't see nobody, no. No, my baby was just standing, looking.
You were fighting and looking at the baby?
No, can't do that, the two things at once. We were fighting in a hall thing. I had Sharon uppercutting her.
I'm sorry, I missed that.
I was uppercutting her.
Okay, so you're, let me ask you something. So how does the fight between you and Sharon start?
She was coming in from outside. And I stated, I don't know why you're here.
Okay, and then what happened?
And then Sharon stated, like, I can be here, something smart like all this that she said. And
Okay,
that's when the fight started.
that's when you struck her?
I'm sorry?
Is that when you struck her, Sharon?
No, Kaylin hit my sister Aisha, and that's when the fight started.
Okay, so are Kaylin and Aisha having any conversation?
No, she stuck my sister from behind. Kaylin did. And then that's when the whole fight between me and Sharon happened.
So so Kaylin, according to your recollection, hits Aisha, and then you hit Sharon.
Yes.
And then you and Sharon fight for 20 minutes. And during part of that, you're uppercutting Sharon. So are you uppercutting Sharon and keeping an eye on Micah?
No, but I'm looking at my daughter. I see my daughter, she's not too far from me now. That's what I'm trying to tell you.
Okay,
She's
so
right,
let me ask you something.
right where the prosecutor was at.
Okay, so
the fight is like right here. It's not that far.
I got you. Can you just describe the uppercutting that you're doing while your daughter's watching?
There's objection to it. I mean, we were fighting and I was,
Let the record reflect that the witness has extended, I guess that would be her left hand, and she's making a punching motion from the top to the bottom, circular motion, with her right for the other. And the time that you're doing that for about 20 minutes, are you also looking at your little girl?
Yes.
Do you see her face or anything?
She's just standing there looking.
And you're hitting somebody?
She was hitting me as well.
Okay, all right. You're uppercutting someone.
Yes.
Is there anyone else engaged with Micah at this point?
Judge objection as they answer. Okay.
So do you remember seeing Caitlin after you said Caitlin and Aisha?
Yes.
Where was Caitlin?
Standing by my daughter.
Okay. And that's when you said she hits her.
Yeah.
That Caitlin hits Mike.
Yes.
What did you do at that point?
I left Sharon and I went towards my daughter to say, I see somebody had helped me and my daughter, so I was going towards Kaylin. Yes.
Okay. All right. Okay, I don't have any
Any redirect?
Not at this time, Judge.
Ma'am, I'm gonna pass you back these, equals exhibits 1 through 3. I'm also giving you an e-pen. On each of the exhibits, can you circle or put a star by or show me what you're trying to show as to the injury to your daughter in each individual exhibit? All right, so for the record, exhibit 1, she placed a circle around her eye, her, what would be the left eye. And exhibit 2, she placed a circle around what would be the right eye. And then in exhibit 3, she placed a circle around what would be the right eye. All right, any questions based on my question?
Sir, may I approach you?
You may. Well, Officer Grant. I tried to turn the picture around. Like, sorry.
Then I do have one question.
Okay.
Ms. Brent, do you recall what day the picture was taken?
The same day, May 13th.
The same day as the incident?
Yeah.
I have no further questions.
Ms. Stevenson, anything?
No, thank you.
All right. Okay, ma'am, you may step down.
Does the court want me to say?
Yes, ma'am. The witnesses will stay in the courtroom. Any other witness on behalf of the people?
No, Your Honor.
The people rest?
The people will rest, Your Honor.
I'm sorry, I had another question. Can the attorneys approach before, can the attorneys just approach? Yes, please. All right, then okay. I apologize. Did people say yes to my question? Will you rest? Okay. Will there be anything on behalf of the defense?
Yes, Your Honor.
Okay. What on behalf of the defense?
On behalf of the defense, Your Honor, we would call Ms. Sharon Jones.
All right, so it is, it's 12:18. So I'm thinking this probably is the better place to take the lunch break.
Okay.
And then come back, at 1:20. And we can resume. All right.